Okay, good afternoon, everybody. My name is Kate O'Regan. I'm the director of the Bonavera Institute at the University of Oxford, and it's a great pleasure to welcome you to this edition of the Bonavera discussion group. Today, we're going to be talking about the cab rank rule in the Commonwealth, and I'm really delighted to welcome our panelists today. First, we'll have Helen Mountfield QC, who's a distinguished human rights barrister at Matrix Chambers in London in her past life, or partly in her present life. Where she's also the principal of Mansfield College, which of course is the home to the Bonavera Institute in Oxford. Thanks very much for joining us, Helen. And then we have Geoffrey Budlender, senior counsel from Cape Town, who's a distinguished human rights lawyer in South Africa with a long history of representing clients both during the apartheid period in relation to claims to protect people from the apartheid state, and in the post-democratic era in terms of asserting people's rights under the newly democratic constitution. Thanks very much, Jeff. It's great to have you here. And finally, we've got Gautam Bhatia, who is based here in Oxford at the moment and is a doctoral candidate in the Faculty of Law. But before he came to Oxford to commence his doctoral studies, he was a practitioner in Delhi, at the bar in Delhi in India. And it's great to have you two here as well. Thanks, Gautam. So somewhat unusually for the discussion group, the process today is going to be more in the mode of a discussion, and each of our panel members will speak for about 10 minutes talking about what the cab rank rule means in their jurisdiction, their own experience of it, what they think the difficulties and challenges are that relate to it. And then we'll have potentially a conversation briefly amongst them, and then there'll be time for Q&A. For those of you who don't know, the Q&A button is in the bottom right-hand corner of the screen. And if you will just enter your questions there, I'll moderate those questions once we come to Q&A. So please feel free to do that. Right, well, I think we'll then turn straight over to Helen.
Okay, thanks very much, Kate. So I thought I'd start by just explaining the ambit of the cab rank rule in the UK, because I imagine this is quite an international audience, and sadly I can't see who you all are, but people from various different jurisdictions, and the rules do operate in slightly different ways in different jurisdictions. So I was brought up from the first day that I stopped being a history student and started to become a law student and then a lawyer, with the cab rank rule. It was always the answer to the dinner party question of how do you defend somebody you know to be guilty. Well, it's not your role to decide if this person is. There is a rule which requires you to take on a case for anyone who's prepared to pay you. That's the simple version. It's based on the rules that apply to London taxis. Again, I don't think this is a universal, and it certainly doesn't apply to the various hailing apps which now exist. But a London black taxi has to take anyone who puts their arm out to wherever they want to go within a certain zone if they have their light on. So that's why it's called the cab rank rule. And in the UK, barristers, but not solicitors, who I think are called advocates in various other split professions, have to comply with it. So those who specialise in the advocacy in front of a court have to comply with the cab rank rule, but solicitors' firms don't, although they do, of course, have obligations not to discriminate, at least on unlawful grounds like race and sex and sexual orientation. So I'm going to talk a little bit about what the rule actually says. And then I think there are some questions about whether it's ethically the right rule, why, what its ethical foundation is, and if so, why, and to what extent, whether it should apply to legal persons or just to natural persons, and if so, in particular, whether it should apply to governments. And also, I think something that I don't want to trespass too much on what other people are going to say, but if the idea is to promote access to justice, are there any other necessary corollaries which ought to go with the cab rank rule? For example, maximum pricing or making oneself available on particular occasions. And what exceptions should there be? There have been some quite controversial questions around the cab rank rule and particular individuals here in the last few months, and I'm not going to talk about those. I'm planning to talk about the rule in its particular, in its broader ethical sense. So if I start off with what the Bar Standards Board rules say in the UK, Rule C28 for it is it, says that you must not withhold your services or permit your services to be withheld on the ground that the nature of the case is objectionable to you or any section of the public, or on the ground that the conduct, opinions or beliefs of a prospective client are unacceptable to you or to a member or section of the public. So you can't pick and choose your clients depending on your own political or other ethical beliefs or your perception of the moral worth of the client. That's the first part of the rule. And then the cab rank rule proper, which is C29 in the Bar Standards Board Handbook, says that if you receive instructions from a professional client, so pausing there, the bar in the UK being a referral profession, it only relates to instructions through a solicitor, and barristers can now take cases on direct professional access. So the cab rank rule doesn't apply to direct professional access at all. But if you receive instructions from a direct professional client and you are a self-employed barrister and the instructions are appropriate, taking account of your experience, seniority and field of practice, then you must, subject to exceptions, take the instructions irrespective of the identity of the client, the nature of the case, whether it's publicly or privately funded, or your opinions on beliefs about the character, reputation, cause, conduct, guilt or innocence of the client. So you have to take the instructions, provided they're not too difficult or too easy for you. You are free and you have the expertise, and you've got a solicitor who is prepared to pay you. But if you're not paid what you regard as your proper fee, and there isn't very much fee transparency in England and Wales, which is the jurisdiction I know about, you don't have to take the case. And there are exceptions. One exception is if taking on the case would create a conflict of interest, which is a debatable issue. And then it doesn't apply also if the instructions would require you to work in do foreign work or instructions acting for a foreign lawyer. So it only applies strictly within the jurisdiction of England and Wales. And some of the recent controversy has been about cases that come from the Commonwealth, because English barristers very often are instructed to apply to work in other jurisdictions where the law of England and Wales, or law based on the law of England and Wales, applies, or occasionally in the Privy Council. And there's a debate about whether the Privy Council work in the Privy Council is covered by the cab rank rule. I think that probably the better rule is that it isn't, because of a case called Willers and Joyce in 2016, where the Privy Council said it wasn't a court of England and Wales. So the next question is, well, why? Why do you have this rule? And the ethical basis for the rule is said to be to protect access to justice and the rule of law. And there was recently a report chaired by Baroness Ruth Deach, who's a lawyer and a former head of an Oxford college, to look into this. Does the cab rank rule still have a purpose? And the ethical basis for the rule is said to be to uphold the role of barristers in upholding access to justice and the rule of law. So there are various roles in the legal system, but the role of the advocate in the courtroom advocate, is to advance a case, any case. And that if lawyers are associated with their clients or subject to intimidation or threats, that may be inimical to access to justice and the rule of law, because barristers may be reluctant or even fearful to undertake that role in the legal system, which is a central facet of it. So it's part of people obtaining a fair hearing. And it has recently been pointed out that this isn't just the rules of the Bar of England and Wales. Principle 18 of the UN Basic Principles on the Role of Lawyers also says that lawyers shall not be identified with their clients or their clients' causes as a result of discharging their function. And the UN Special Rapporteur on the independence of judges and lawyers reported in 1998 and gave a rationale for that, again, that if you identify a lawyer with their client's cause, although the Special Rapporteur said unless there is evidence to that effect, So you just assume that by representing someone, a lawyer is associated with the cause, that could be construed as intimidation or harassment of the lawyer concerned. So that's the rationale for the rule. I suppose the question then is, to what extent do you need that rule? It's one thing to say lawyers perform this function, they shouldn't be associated with their client. It's part of the rule of law to recognise that that's the role they're playing. Do they need effectively the fig leaf of the cab rank rule, the protection to say, well, I must do this? Or can they just say, I may do this and it is an appropriate role? Is this actually necessary to stop them being intimidated or harassed, or to have social or professional pressure not to take on particular clients? And I guess that's one question. The second question is, if it really is necessary, then why does it only apply to the courtroom advocate and not to the entry point for most cases, which is the solicitor? If you can't get a solicitor or a direct professional access barrister, then you would never get to the point where the barrister in the courtroom was acting for you on the cab rank rule. So that's a bit of a puzzle. I guess the other question is whether it really needs to apply to legal persons as well as natural persons. So clearly you can see the rationale for saying, if I represent somebody accused of heinous child sex abuse or something, I don't want anyone to think that I am associated with this person or I'm making a moral case. I'm testing the evidence, working in the justice system to ensure that there's a fair hearing, and it isn't my role to be the judge. Does that apply to a bank and a big professional firm? Is it necessary for equality of arms? And in particular, does it apply to governments and public authorities? In this country, wasn't the case when I first came to the bar, but it was the case following a big sex discrimination case about 25 years ago. The government doesn't just instruct anyone at the bar. It has a panel of advocates. It's a competition to get onto the government panels of advocates. And they don't have to instruct anybody, and they don't instruct anybody. You don't have to apply to be on the panel. So does it make sense then to say that the cab rank rule applies to public authorities as well as private people? And if so, why? I think, and perhaps another problem is that there isn't a definition of the proper fee. And I used the term fig leaf a moment ago. There are some people who regard the cab rank rule as incredibly ethically important, and others who say, well, it's there to protect you if you get attacked, but lots of people can get around it. They're too busy that day. Their fees are very high. And given that there are no set levels of fees or maximum fees or duty to publish fee scales in the UK, arguably the cab rank rule only applies only protects the rights of access to the court of the very rich. So there's a problem there. And the question is also, does it stop, which the Law Standards Board report, the Deach report recently suggested, it would stop, for example, a bank buying up the best lawyers at the bar by saying, we will pay you not to represent anyone other than us. That would be unethical, but I am certainly aware of people who have been paid a very large brief fee to give all their time to a big case for a bank for a particular period of time. And that isn't unethical if we want you to be there available for us at any time to represent our interests for the duration of this case. But it arguably has exactly the same effect. So question, does the cab rank rule really work to stop people buying up people who may otherwise represent the opposition? And finally, do you need, come back to this question, it's one thing to say that barristers or lawyers need protection from intimidation. It's important to set out the ethical code that it is a proper thing for a barrister to do, to represent particular clients without judging or without being seen to be associated with what the client may be alleged to have done, or public opinion associated with a view or a person who is unpopular in the wider court of public opinion. But do you need a code that requires people to take on cases come what may, which many people know is not strictly adhered to? Or is this really a question of culture and ethics? And there are other democracies governed by the rule of law that don't have a cab rank rule. So I suppose there is a question of whether you need it or whether it's a convenient fiction for lawyers. And I do think it's important to protect lawyers and judges, but not for its own sake or for their own sakes, but because of the roles they play in the justice system. And it is a nuanced question how far you need the cab rank rule to make that happen. So that was all I wanted to say in opening, Kate.
Yeah, that was really helpful, very clear, and exploring a lot of the difficult issues that arise. Thank you very much. We'll now turn to Geoff, and just to remind people, don't forget to put your questions in the Q&A if you've got questions you'd like to put to the members of the panel. Thanks. I'm struggling to hear you, Geoff. I'm not sure if other people can hear Geoff. It doesn't look like you're on mute, but I'm just wondering.
Is this any better now?
No, not really. Okay, so what I think I'd suggest you do is just go out and come back in again, and we'll ask Gautam to speak in the meantime, and hopefully that will solve the problem. Sometimes, and you'll obviously get the option to click on the audio as you come back in. Okay, great, thank you. Okay, Gautam, I'm sorry I think we'll jump over Geoff and go to you while we see if we can sort that out.
Sure. Am I audible, Shirley?
Yes, you are.
Okay, thank you. Thanks for setting that out so clearly. I thought I really began to think about these issues in a deeper way a few years ago when there was a serious controversy back home in India. This involved the rise of the Indian Me Too movement, and it involved the accusation of a senior government minister of multiple cases of sexual harassment. That government minister then filed a case of criminal defamation, which still exists on the Indian statute books, against the journalist who had first broken the story. And then there was a photograph doing the rounds on various lawyers' WhatsApp groups that showed a very prominent corporate law firm representing this minister, and the signature of 99 lawyers on that firm's form, that representation form. And of course, that was a very intuitively powerful image of here's a journalist who broke this news about this powerful minister, and here you have 99 lawyers all arranged in a row to try and get her put behind bars or get her convicted. And so that led to a lot of debate in the Indian public sphere, and the common defense advance then was that these lawyers are only doing their job, and so they shouldn't be condemned for their choice to represent this government minister. And that felt intuitively wrong to me. And so I began to think a little more, and that led to me developing a few more thoughts about the cab rank rule, which does exist in India as a formality. There is a rule that says that advocates cannot decline briefs unless special circumstances exist, and as long as they are paid a fee that's commensurate with their standing at the bar. So I thought that it seemed to me that we do have a common and basic intuition that all of us should be held responsible for the consequences of our actions. And if you think of the role that lawyers play, their actions are hugely consequential. They could lead to someone being executed or not being executed, someone losing their home, being evicted or not being evicted, and so on. So there are very serious consequences to the actions of lawyers in court. And so at first blush, it seems that there is something counterintuitive about the cab rank rule. But then when I thought a little deeper, it struck me that this counterintuitive nature comes from the fact that what the cab rank rule essentially seeks to do is to take that choice away from individual lawyers in the interests of preserving the adversarial system of justice. And so then the argument goes that because lawyers do not have a choice in picking their clients, therefore they are shielded from moral scrutiny of the cases that they take up. And this shielding is very important if the adversarial system of justice is to survive, if unpopular clients have to get representation, and so on. And so that is the important role that the cab rank rule plays in the context of justice system. But then it struck me further that the very important exception that the cab rank rule sets out is quite problematic, because what it says is that you can still decline a brief if the fees that you charge commensurate with your standing at the bar is not met. And that, to me, at a very basic level, makes the analogy fail, because cabs don't charge differential fees. I mean, your fees, the money will vary depending on how far you have to go. But it's not that an individual cab will charge you, a much higher fees. And of course, cab fees are regulated. There is a ceiling based on the distance traveled. So for me, the analogy broke down there. But more importantly, it broke down because of two things. One is that I don't really see a morally salient distinction between turning down a client because you don't agree with the views that they espouse or the conduct that they are allegedly deemed to have engaged in, or who they are or their cause, on the one hand, and declining a brief because the client can't pay on the other. So it seems to me that there is no real morally salient distinction between these two reasons to decline a brief. And indeed, I think that if you look into it a little deeper, there is a clear link between the ability to pay and the kind of case, right? So for example, survivors of domestic violence or laborers in a management dispute, which were two of the major kinds of cases that my first chamber used to take, they're not going to be engaged in complex, high-stakes corporate restructuring cases, right? Which big firms engage in, and so the very fact that fees becomes a distinguishing feature in what cases a lawyer can choose to accept or not implies that certain lawyers will be doing certain kinds of cases and are actually selecting kinds of cases, because there is a link between people who can pay and who can't, and the kinds of cases that those people are going to engage in. Of course, it's not a complete overlap, but there is a fair bit of overlap in the kinds of cases tracking ability to pay. And which is why I think that the cab rank rule would make sense if, like the National Health Service, there existed something like a national legal service where access to lawyers was free at the point of use, and the entire system was nationalized. And I believe that Frederick Wilmot Smith has actually proposed something along those lines in a book called Equal Justice. So I think that something like the cab rank rule would make perfect sense within that broader context, in which money was not a distinguishing factor in determining what kind of representation you can access and what you can't. The second thing I want to bring up is that there is a very valid reason why people defend the cab rank rule, and that is the defense of unpopular clients. In India, we have often seen of late that there are problems in lawyers trying to defend people accused of terrorism or of rape. Often they are physically restrained from representing these kinds of cases that lead to great public opprobrium. And of course, you need to emphasize upon the principle that everybody has a right to a defense, and that defending people accused of heinous offenses is actually morally correct. And my view there is that it's important. So I think the answer is not to use something like the cab rank rule to justify a complete moral shielding of lawyers from the cases that they take, but to actually address the moral issue head on and say that there are good moral reasons why, in, for example, criminal cases, everybody needs a defense. And for me, that reason lies in the fact that there exists a great imbalance of power between the state and the individual in the criminal law context. And furthermore, often criminal law cases involve complex issues around procedure, and procedural protections that extend beyond just that client and go, have a much deeper impact. So in that sense, I think that it's not that the reason why we defend lawyers taking on unpopular clients in the criminal law context is not because we should dissociate lawyers from the case and refrain from engaging in moral or ethical scrutiny, but because it is morally good for lawyers to do that. And I recall the international criminal lawyer Kevin Jon Heller a few years ago had a wonderful blog post on Opinio Juris where he explained his reasons for defending Radovan Karadzic in the ICTY. And many of the points I make here were made by him. So I think that we can reconcile our intuition that the choices we make should have consequences with our intuition that lawyers who take on unpopular cases, specifically criminal cases, should not be pilloried or should not be condemned for doing that. And I think therefore that there is a distinction between, say, a lawyer defending someone accused in a criminal case on the one hand, and a lawyer weaponizing something like criminal defamation, which was the example that I began with, to go after, say, a journalist who broke this news against a government minister. I think in both cases, what matters is considering power relations. And the fact that law can either be used to interrogate power, to challenge power, and to break down the hierarchies of power that exist on the one hand, but it can also be used to entrench power relations and to further strengthen those power relations. And I think that our ethical scrutiny of what lawyers do and decide to do should be based on what impact their role has with respect to the relations of power that exist in our society and the role that law plays to either entrench them or to interrogate them. So I think that to sum up, what I would say is that I think that the cab rank rule is important in some ways, but needs to be understood in a slightly more nuanced way than it is. In contexts like criminal law, it can serve a very important purpose. In other contexts, perhaps less so. But in all contexts, there is a moral valence to the decisions lawyers take with respect to representation, and that issue needs to be addressed and not avoided. So, thank you.
Great, thanks, Gautam. That was really interesting and raised some very important points. Geoff, I'm hoping you might have solved your microphone problems
with multiple assistants. Can you hear me now?
We can. Perfect. Excellent. Well, thanks for the assistance and thanks for persisting.
Okay. Right. Can you still hear me now? No.
We can hear you. I'm just putting myself on mute so I don't interfere, but we're hearing you loud and clear.
You're hearing me fine now.
Yeah,
okay.
So go ahead. You've got your 10 minutes and please feel free. If there's any problems, I'll let you know. But
okay, thank you. Thank you. So I wanted to put up a series of propositions from the theoretical to the practical, starting with the theoretical. The first proposition is that it's an essential requirement of the rule of law that people have effective access to justice. That means they must be able to obtain competent representation. And to the extent that the cab rank rule seeks to promote the achievement of that goal, it has a legitimate purpose. That's proposition one. Proposition two is that we all have moral agency. Our actions have consequences, and we are morally responsible for the consequences of our actions. And so we should reject the approach. Some people of a certain age who are listening may remember Tom Lehrer, who sang a song about Werner von Braun, who made rockets for the Nazis during the Second World War and then made them for the United States after the war. And Tom Lehrer said that Werner von Braun's philosophy was the following: once the rockets go up, who cares where they come down? That's not my department, says Werner von Braun. And that's not a view we would support. The third proposition is that there's a tension between these two moral principles. The need, on the one hand, to ensure that those who need competent legal representation get it, and on the other hand, the need to accept moral responsibility for the consequences of one's conduct. And the question then is which one trumps and when? That brings me to proposition 4, which is that I think it is a necessary and fundamental qualification of the cab rank rule that there are circumstances in which the rules of moral agency trump the duty to provide competent representation to those who need it. I think the most passionate and effective defense of the cab rank rule that I've read recently was by Sidney Kentridge in a talk on the ethics of advocacy. He defended it with passion and then said, are there occasions when counsel should be entitled to follow his or her conscience and refuse to act? And he referred to cases in which counsel had been briefed by the apartheid government to enforce apartheid laws. And he said, if he'd been offered such a brief, which he said he wasn't, I'm sure, I believe that I and many other advocates would have been unable to comply with the cab rank rule. Perhaps no rule of conduct can be an absolute rule. There may be times, fortunately rare, when one's own conscience rather than the general rule must govern one's conduct. And let me give you 3 practical examples of that, of which I know in South Africa. Firstly, a leading counsel, later a judge, defended an interpretation of a detention without trial law, which had the effect that detainees were held incommunicado, without access to family, without access to lawyers or independent medical treatment. And that system of incommunicado detention enabled torture, and it resulted in deaths in detention, predictably so. So was it justifiable for that advocate to assert an obligation to take on the case and argue it on the grounds of the cab rank rule? Second, the pass laws, which were a foundation of the apartheid legal system, were also inhuman. They made it a crime for the wife and children of African men working in the cities to live with them, broke up families, and was a prop. The laws were a key prop of apartheid. When the meaning of that law was litigated, was counsel obliged by the cab rank rule to appear for the government and defend that interpretation? The third example, South Africa's so-called homelands were apartheid constructions which were designed to deny Africans political rights in the bulk of South Africa. Some of these homelands had constitutions which purported to guarantee human rights. A professor of human rights law who was an admitted advocate appeared on behalf of the government concerned to defend the constitutionality of detention without trial. When challenged, he said he was simply following the cab rank rule. Was that valid? In my view, in each of those cases, it wasn't, or it shouldn't have been permissible for counsel to duck the moral question and rely on an obligation under the cab rank rule to accept the brief. That's proposition 4. Proposition 5 is relevant to the sometimes overstated defense of the cab rank rule. It's this: the rule of law doesn't imply that every person has the right to counsel of their choice. What the rule of law guarantees is a right to competent legal representation. Advocates aren't known for their modesty, but even advocates would seldom claim that they're the only person who could provide competent representation. So the rule of law moral justification doesn't really apply, it seems to me, where the person concerned is able to obtain competent representation from another practitioner. It seems to me, then fifthly, there's the point that Helen raised, the fact that the rule applies only to advocates in our system, not attorneys or solicitors. And it seems to me the one-sided nature of the rule is incongruous and difficult to explain. The simplest explanation, perhaps the most cynical explanation, is that the attorneys or solicitors firms protect their commercial interests by picking and choosing whom they will represent. I hope that's not too cynical. Then to come to the practical, proposition 7, the truth is that busy advocates or counsel make decisions all the time about whether to take on a case. They of course have regard to their ability or their capacity to take it on in the light of their other obligations. But when they turn down an offer of a brief, they usually say this is because they are too busy to take on the work. But everyone knows that in practice they also consider other matters: the nature of the case, whom they'll be working with, the fees it's likely to produce, and other factors. I was told a story recently about a very eminent senior counsel in Johannesburg who was pressed by an attorney and a would-be client to give a reason for declining their brief. He finally said, look, the brief is boring. Now, given that the client in question had plenty of money and was able to obtain the services of other very competent counsel, why does that frank answer disclose a moral breach of some kind? The next two propositions arise from the fact that the essence of the cab rank rule is that it imposes an obligation, because it requires counsel to accept briefs which they otherwise would not wish to accept. My experience suggests the following, is proposition 8. In truth, The cab rank rule is most frequently deployed where counsel wants to take on a brief, but feel uncomfortable about the morality of the case. And so they say to themselves, well, I have to take it on, I'm obliged to do so. In other words, it's most frequently marshaled as a justification for what counsel wants to do, rather than an obligation to do what counsel doesn't want to do. In those cases, the rule is actually self-serving. It enables counsel to take on whatever case they want, to earn a fee, perhaps the publicity which will be involved, without having to engage the moral question which the brief raises. In those cases, the rule doesn't promote the rule of law, rather it enables counsel to take on whatever case they want without ever having to justify the decisions. It seems to me there's a problem with that. Proposition 9 is I want to suggest that here in South Africa, at least, there are really very few counsel who take on cases they don't want to take on, and who do so only because they believe it's an obligation under the cab rank rule. There are, of course, some counsel who believe that it's the professional obligation of counsel generally, regardless of the cab rank rule. For them, the cab rank rule just provides a justification or a cover for what they would do anyway. And I accept, of course, that it's a good thing, it's essential, that the unpopular clients are unable to obtain high quality services. And the cab rank rule does facilitate that. But I doubt that it can justify a compulsory rule. Then finally, one of the matters that I think Helen raised, one of the justifications offered for the cab rank rule is that it's a necessary element of an independent profession, because a corollary of the rule is that counsel must not be identified with their client. That's proposition 10, is that this strikes me as very weak. I was struck, Kate, by the fact that you introduced Helen as a distinguished human rights lawyer. Well, why is she a human rights lawyer? Because she does a lot of human rights work. She's identified by the work, with the work which she does. Sidney Kentridge wrote, I hope I may regard myself as a human rights lawyer. Justifiably so, because throughout his career, he undertook human rights work, not simply when somebody offered him a brief, but because he believed in the justice of the cause that he was asked to espouse. He identified and was identified with his clients and their cause. Cab rank fundamentalists say that this is somehow out of order, and I doubt that that can be justified in either principle or practice. So I've got really a modest proposal that the rule does serve a purpose, but I think it needs to be qualified in two respects. Two conditions need to be met, I think, before the rule can really be applied as a rule, as opposed to a guide. Firstly, the rule can be justified if a refusal to accept the brief will likely have the consequence that the client will be deprived of competent legal representation. That, I think, triggers an obligation. Secondly, and more importantly from my point of view, in the light of where the issues that play out in South Africa and have played out, I believe that if that counsel ought to be excused from the rule shouldn't apply. If counsel's conscience does not prevent, let me say it again, that the rule shouldn't apply if counsel's conscience prevents acceptance of the brief. That, of course, is an elastic qualification. It requires justification on a case-by-case basis, that this case I can't take on because I find this case morally repugnant, or the consequences of this case morally repugnant. So justification on a case-by-case basis is required, but that, of course, is precisely what moral agency and moral choice require. They require us to look at the facts of a particular case and make a decision based on the facts of that case. That, I think, is what moral agency is about. Thank you, Kate.
Thanks very much, Geoff. That was really clear. I mean, could I just come back to you on your last two qualifications? Would the first qualification be relevant to the second qualification? In other words, if you thought that your conscience would not permit you to take the case, would it be relevant to your justification whether the would-be client would otherwise be legally represented?
Yeah, I think it would have to. I think you'd then really be in a situation of having to balance two moral imperatives. And the prospect of someone going before a court, possibly a criminal court, and having very serious consequences without representation is so serious that you might have to say, well, I think the second rule gives way in this case. I think that may be the case.
Yeah, well, thanks for that clarification. I think it was all three of these presentations really, clearly considered the issues at play. I'd like to just come back before we turn to questions, and this is an opportunity for those of you attending to put more questions into the list. It's just so Gautam raised the issue and Geoff followed up on it about the distinction between criminal and civil proceedings. And I mean, do you all agree that there is something particularly acute about the interests that underpin the cab rank rule in the context of criminal proceedings, particularly where Geoff's first qualification applies, that is, where the person may really risk the possibility of not being represented?
I mean, I can kick off. I think there is a very clear and easy explanation for the cab rank rule in the context of certainly criminal defence. But yes, so because otherwise the more heinous the crime, the more unattractive the person, the more politically unpopular they may be, the less likely it is that they'll get as good a representation as they might in our context. And I think that's very important, and equality of arms is obviously extremely important there. But I was thinking about the distinction that Gautam was talking about asking the question about who has the power. Are we ensuring, trying to equalise power in a courtroom? And that harks back to the issue I was raising about whether the cab rank rule ought ever to apply to a state. And there's perhaps a distinction between the apartheid South African government and a constitutional democracy on that question. But when you're looking at the power, in a sense, that brings lawyers into some of the questions that perhaps the court itself needs to raise in a controversial case. I'm thinking, for example, of a case I did a few years ago where I was representing a local authority which wanted to prevent a registrar of births, deaths and marriages from registering marriages because she refused to register same-sex marriages or civil in fact I think it was civil partnerships in those days. And so one might say, well, that was a case where the people with the minority of power were the sexual minorities who were not being afforded the equal right to be married, although in fact they were. Anyone could marry them. This was a question of whether she could put her individual conscience above the civic duty to perform marriage without discrimination on grounds of sexual orientation. But it could equally be argued that she was being discriminated against as a member of a religious minority whose conscience was not being properly protected because it was a minority belief and it was not it was not the majority view that had been passed into a statute by a democratic government about the rights of individuals to be married. So these are very complicated questions, and I can see a justification for saying that there is a moral case, as you were saying, Gautam, for saying the moral thing for me to do is to not express my own personal views in this context. Outside this context, I can say what I want, but in this context where I am being a lawyer, I am ensuring that the point of view that my client wants me to put forward is the right one. So it's quite tricky. I mean, I think you certainly couldn't exclude the cab rank rule from, for example, election law, probably family law, but there are certainly areas of public law where I can see a real difficulty if you do start to be associated. On the other hand, as Geoff says, it is unrealistic to suppose that judges do not know the advocates who regularly represent the government, or the advocates who regularly represent particular groups in the courts before them, because they do in those cases. It's not to say the cab rank rule doesn't then have a purpose there, because I think it does. That you can say, well, it's not me being ornery, it's me representing this case, and here it is, and now you have to listen to it. But I think the idea that we're all completely blind when we just hear the voice, it's as if a computer was putting the submissions or as if they were in writing, just isn't realistic, really.
Well, thank you. Anything you'd like to supplement there, Gautam?
Yeah, so it's interesting you raised this point because last night and this morning I was discussing these issues with both the first lawyer I worked with, and the first time I walked into his office, he said the guiding principle is equality of arms, and that's where I learned a lot of this. And with a close friend who's also been thinking about these issues. And when I said that there should be a distinction between criminal law and non-criminal law, because of the issue of power differential, they both raise the possibility of the fact that they do exist there do exist extremely powerful individuals whose, like economic, social, and cultural resources are to an extent where they're not really less powerful than the criminal justice system. This may not be true in all countries, but we could immediately think of examples in India where if like a certain individual was arraigned in court even in a criminal law case, you couldn't really say that he's the powerless one there because of the amount of resources that they've accumulated. And so that seemed like it seemed the point at which the argument seemed to maybe reach its limits. And so I think that maybe a clean-cut distinction that applies to all cases, criminal and non-criminal, may still throw up these kinds of borderline or gray areas where the argument breaks down. But I think that the basic point, which is that in an ordinary criminal case, by representing an accused, no matter what they're accused of, it is towards establishing equality of arms. And I think specifically with respect to ensuring that the procedural safeguards that underpin criminal law are maintained, because in my experience, in every criminal case, the state tries to push the envelope further and try to dilute those procedural safeguards more and more. So I think that therefore, something like the cab rank rule, I think in criminal law context continues to retain, I think, importance. But as I said, not because you shouldn't associate the lawyer with the case or say that there is no moral question at all, but because there is a very good moral reason why lawyers, in fact, the best of lawyers, should be placing their services, in those kinds of cases. Whereas in non-criminal law cases, there's more of a case-by-case understanding of where the power lies and what it does. And I think maybe another way of looking at it is that as a lawyer, is my representation in this case going to, and if I was successful, will it have the effect of expanding rights or contracting rights? And in a criminal law case, if you're representing the accused, I don't think that representation will have an effect of contracting rights in general. In fact, often it will have the effect of expanding procedural safeguards and so on. Whereas in non-criminal cases, it could often depend. So maybe that's one way of thinking about it to when we think of the moral or ethical questions that are attached to these kinds of cases.
Just one thing on the civil.
Gautam, how does that apply in a conflict of rights case?
Sorry, should we just go to Geoff first, Helen, and then we'll come back to you?
Sorry.
Just a brief thing on the civil and criminal divide. It seems to me the criminal situation
of course, yes,
is par excellence the argument for the cab rank rule, for all the reasons that everyone has given. But there are many civil cases in which fundamental moral issues arise. Issues, Helen rightly mentioned, family law situations, issues about marital property, which have been litigated a lot in South Africa recently. I'll be blunt, I was offered a brief in a matter in a neighboring country involving marital property, and I said I wouldn't argue that case. I won't argue that case anywhere, whether in South Africa or Botswana, because the proposition that was being argued I thought was utterly offensive. And I think that will arise in some other civil cases as well.
Thanks, Geoff. Helen, back to you.
Well, it was only asking Gautam how the is this something that expands rights or contracts them, how that applies in conflicts of rights cases, or in a case where somebody may be saying the state has a positive obligation to protect, as balanced against the person who's defending. I'm thinking of the recent case about the parole and whether it took into account relevant considerations in deciding to release a serial rapist without taking account of the views of victim or alleged victims, complainants in cases that had not been prosecuted.
Oh no, so completely. So I think that in those kinds of cases, that should exactly be the discussion that we're having, is what does the balance of rights entail. And again, to take the example of the criminal defamation case that I mentioned earlier. Now, a lawyer representing the government minister in that case could well make the argument that actually I am protecting the right to reputation, which is important. And I think that then we should have a discussion on on whether on the role of criminal defamation in a society, specifically in the context of something like Me Too, where the whole effort is to find a vocabulary to express certain kinds of incidents, that vocabulary didn't exist before, and so on. But that's the discussion then that we should be having. Is it actually a balancing of rights, or is it actually is something like criminal defamation just a vehicle to try and shut down people? So I think that there will be many complex cases of the kind that you have mentioned, and for me the answer then is to engage with the complexity of those cases. And I know that you said a little while before that a part of that is the task of courts. And I think that that's completely true, but that needn't also stop lawyers from engaging as well with that complexity. I just think that so the distinction in my mind remains between saying that everybody has a right to be represented and lawyers have a right to represent any client that they choose on the one hand, which I think is completely true, and saying that there should not be attached any moral or ethical scrutiny to the choices lawyers make. And I think the weaker claim is the one I'm supporting, that all these decisions that involve these complex issues should be engaged with on those terms. And as Geoff said, maybe ultimately the answer simply is that yes, this person deserves representation and should be represented, but should it really be you who's doing that representation, the generic you? So I think that might be where it ends finally.
So, I mean, I think there's a sort of an agreement here that there are, which is how Geoff formulated it, that there's a tension at times between the rule and in facilitating legal representation and the kind of moral duties of a lawyer. And one of the things that struck me, and maybe this is a sort of perspective from the bench in a way, is that lawyers represent different clients very differently. And there is no doubt that in a framework like in a constitutional framework like South Africa, where there are a very clear set of constitutional principles and values, sometimes it's really helpful to the project of justice to have lawyers representing people who may be unpopular, but who are in some ways playing an educative role in persuading their clients that certain arguments shouldn't be made and certain arguments are constitutionally acceptable, and that there is a role that lawyers play in the way they represent people. And how should we filter that into the moral agency? I suppose it starts a little bit with the extent to which clients are willing to listen to your advice as to what's constitutional or not. I'm looking partly at Geoff because I know he has played this role in cases. And how should we think about that in balancing this kind of cab rank duty together with one's own sense of moral agency?
I do think the lawyers have an impact on the clients, but there's something a bit odd about taking someone's money in order to represent them, to teach them that they're wrong. I don't think you can really go into a case on the basis that I'm here to persuade the client that they are misguided. I mean, unless the client's asking advice, that's a different matter. But in litigation, I think you've got to put your best foot forward.
Yeah, it's not so clear cut. It could be about what is the best way forward, what is the kind of lawful way forward. I mean, it's not simply saying you're wrong, but there's much more that goes on in a case. It's often attached to things that are much more complex than are appearing in the case, and that the role that lawyers play sometimes can be quite significant in making clients understand what their constitutional obligations are, perhaps, and the way in which they should, the way in which they should act.
Sure.
I'm now going to turn to some of our questions, and please feel free to add more. So the first question is to our panelists what they think of the Diana Rose controversy. In particular, so Diana Rose, for those of you who are not based in Oxford, is the principal of Magdalen and has been involved in a controversy about the cab rank rule quite recently. And in particular, the questioner asked whether panelists think her obligations are different because she's the president of a college, as my colleague Justice Edwin Cameron has argued, or whether there's a conflict between her professional obligations and her academic obligations, which should trump. Now, I do know that Helen doesn't want to respond on this question, and it may well be that our panelists don't either, and freedom of speech operates on our discussion group as well. So panelists don't feel they have to answer to walk into this area, but obviously they're also very welcome to do so if they'd like to. So Gautam, anything you'd like to say on this?
Sorry, I muted myself. No, so I think that what follows from my position on this is that this is a question that everybody has to assess for themselves, and I don't think that there is like one specific answer. So I think every person has to see what the case was about, and some of the indicators are about expanding rights or contracting them and things like that, and then it's for every person to take form an opinion on that. So I just say that there are like various indicators, and people may disagree on whether in this case it was just justified or not. Yeah.
I suppose it might be useful, I think, Gautam, just to add here that in this case the question was was whether the people were arguing that Diana Rose should have not used the cab rank rule and should have exercised a moral agency not to take the case. It wasn't so much as to whether it was a justified failure to take a case. So it's a slightly different way of formulating the question to the way that Geoff formulated it in his approach, for example. Geoff, anything you'd like to say about this?
Well, I don't have any competence to say anything about the position of a head of a college, or the obligations of the head of a college. What I would say about it is I think it's important to recognize the legitimacy of raising the question of whether this was a case which this person should have taken on in these circumstances. And I don't think it's appropriate to try to shut it down by saying, oh, well, the cab rank rules, move on to the next question. I think the question is a legitimate one, which has to be answered and perhaps can be answered adequately. But to say there's no need to answer it because there's a rule, I don't find acceptable.
And that's
I think that puts better what I was trying to say but couldn't quite communicate it. I think that puts it in the way I wanted to say it. So
okay, great. And Helen, am I right? Do you want to comment on this?
I will. Yes. Well, no. There are two reasons I don't want to comment on it. One is that I too am a head of a college, and I just don't think it's very fair to put in. But the main reason is that I was also instructed for another client in that case, and I just think it's just inappropriate always round. But I would just point out that Dinah, whose defence on this is published on Joshua Rosenberg's blog, doesn't just rely on whether the cab rank rule applies or not. She does rely on some of the ethical arguments that we've been putting forward about access to justice and the importance of not associating a lawyer with their client. So she's put forward her case on that there, and that can be read as can arguments against does the rule apply, and then the other is if it doesn't, what is the moral case? And she's definitely right on the moral case, not just the strict letter of the rule.
Thanks, Helen. That's useful. And Gayatri, if you could find that, it might be useful for people to have that in the chat. Turning to the question, there's a question then for Geoff, which is all the examples you gave about objecting for conscience concern representing an undemocratic or the apartheid state. Would the conscience exception, do you think, ever apply in a democratic state? Particularly, would it ever apply to representing an individual?
Yes, I think it can apply in any state. Can it apply to the UK treatment of refugees? Whether you'll get involved in litigation of that kind and what kind of litigation? Yes, it applies. I think. Does it apply in Trump's United States? Yes, I think it applies. Does it apply in South Africa? Yes, I think it applies. So of course, I think we all have to show some respect for, or even deference to the fact that laws which are made by democratic process are to be enforced ordinarily. And these laws which I was talking about were all made by an undemocratic state. But I don't think that the fact that the state is democratic or even that the law was made democratically means that its moral validity automatically has to be accepted and results in a binding rule. We've lost you, Kate.
Kate, you're on silent.
Thank you. So the next question goes as follows. Most advocates of the cab rank rule agree there are some moral boundaries, as Geoff has said. So perhaps the real issue is expanding those boundaries to bring morality into more legal issues. How do we judge the morality of legal questions? For example, if a lawyer is representing a case that could be couched in questions of separation of powers and politics versus law, but the outcome of which might deny human rights. So this question really is that we can look at cases in different ways, and the way in which the moral considerations of the case might be raised may differ depending on which where you look at it, which I think Gautam mentioned earlier as well. But how do we, are there ways to recognize that in fact these moral principles might kind of cut in different ways when we're thinking about when as a barrister you think about whether you should take a case, or whether we're thinking about whether we should criticize somebody for taking a case?
Yes, Kate, that's I think the point that I was making, that I quite see that there are probably, well, certainly will have been cases in pre-apartheid South Africa, and the case that Geoff was talking about, where you may say my personal morality goes beyond being prepared to comply with the professional rule here, or and it's very rare, certainly for a senior barrister, that you have to take it on the chin quite that directly. As we were saying, this is effectively a protection for lawyers, but I can see there might be such a case. But the arguments are nuanced, and in a case, in many cases, you say the argument might be about separation of powers or the proportionality of a certain rule, but the consequences may be a denial of human rights. But that's the very question that the judge is deciding. What are the limits of the human right in question here? And is there a direct consequence of something? For example, something I was asked to think about the other day in relation to gay conversion therapy. There is a clear right for religious organisations in this country to set their own rules within the parameters of the strict observance of their religion. You can decide you will only have male priests, for example. How far does that go? What about conversion therapy, which arguably is inhuman and degrading treatment? Can you say, well, that's just within the sphere of the religion, they're not trying to go out into the public sphere, so nothing to do with the world? Or is there a positive obligation on the state to protect people? And these aren't questions where there is a clear answer. That's the question that ultimately it's a question of political controversy, but ultimately, if it were brought and couched as a human rights question, would be for the judge, not for the lawyer. And I do think there is a really quite compelling case to make that, except in the most extreme case, a lawyer is not the person who is making that ultimate moral judgment. They are advancing the arguments within the framework which the Constitution gives for those arguments to be resolved.
Right. Oh, God. Gautam, anything you'd like to add to that?
Yeah, no, I think it's a really good question, and I think that it doesn't have a hard or categorical answer. And I agree with a lot of what Helen said here, that a vast majority of cases are going to be in that realm where there are arguments on both sides, and that's probably why it's going to court. But I'm just thinking of a range of cases that that have come to court in India recently. They involve, for example, the shutting down of internet, in a state for many months. The thing is that there's always a case to be made, on the other side, national security and preventing rumor spreading. There's many things that government counsel say. But I just feel that shouldn't that shouldn't stop, I think, lawyers from thinking about those issues as well, and that informing their choice. And I think that should be part of the discussion. And I think that it's perfectly fine for a lawyer, a counsel, to say that I find this issue morally complex and or at least a close enough call to not preclude me from taking the brief, and ultimately it's the court that will decide the case. So I think that's a perfectly correct and legitimate view to take. And I think it's equally correct for others to say, but we don't agree with your assessment. We think that actually is quite clear and unjustified, and we think that pushing the government's case in this context is unjustified. So I think both sets of views are equally valid, and that is what the discussion should be about.
Yeah, I mean, it reminds me. Sorry, go ahead, Geoff.
No, go after you.
I was going to say it reminded me a little bit of the debates about lawyers disobeying the law. You could just take a view that, of course, lawyers must never disobey the law, and that's the general rule that the professional rules take. But at the end of the day, this is a moral decision, which is what Geoff is saying. We have to remember that we're all moral agents, and there may well be times when actually you have to think it through carefully. And the Bram Fisher example in South Africa, which many South Africans who are on the call will know about, is an example where a lawyer thought through very carefully what the moral responsibilities to the law versus the moral kind of and political circumstances of the time were. And so sometimes just slapping something down like a trump on the table and saying this argument means I win is not actually the way to go. It's much more nuanced and complex than that. Yes, Geoff, sorry.
Just to go back to the previous point, I think for me, there's a need to draw a distinction between whether the outcome of the case that I'm arguing, whether my outcome would be a good outcome, good for the law, good generally, whether it's the better outcome, and whether it is a morally tolerable outcome. We all argue cases in which we have doubts about whether we are right on the law, and in which we have doubts about whether the outcome for which we are arguing is the better one in terms of the law or the facts. That's what we do, and that's what it's for the judges. The judges are there to make that call. And I don't have any difficulty in arguing that case should be decided in a particular way, even if I think that wouldn't be the best outcome. Although I must say, I don't think I argue very convincingly under those circumstances. But I draw a distinction between that and the situation where I believe the outcome for which I'm arguing will be morally repugnant. And if I think the outcome will be morally repugnant, then I think I have a duty not to take on the case, if I take myself seriously as a moral human being. That doesn't mean that everyone else will necessarily agree with my judgment, but that's not what we're talking about. We're talking about whether I, as a morally sentient being, I hope, I'm entitled to say I won't do that because I find the outcome morally repugnant. I think that's fundamental to who we ought to be.
Thank you. Now, we've got a whole lot of really interesting questions, which we're going to have to try and squeeze in the last little while. So I'm going to put them, and then maybe I'm going to read them out, and then maybe you can just decide which ones you want to respond to, because they're all interesting, and I think we'll run out of time if we try to do it. Sorry, Helen, you're on a kind of slightly frozen and a bit delayed. Okay, so I'm just going to go ahead with the question. So the first one is, so is the cab rank rule, it really goes to Geoff's last comment, moderated because advocates have the right to refuse to make untenable legal arguments, and I suppose it would be Geoff's point if it said to make immoral arguments, or arguments that would lead to immoral outcomes, and to withdraw from a case if clients refuse to abandon an untenable argument. And I think that does also link to what I was saying about from the bench's perspective. It is helpful to have lawyers who don't make untenable legal arguments when you're trying to adjudicate a case. Then there's another question. Helen referenced the distinction between UK cases and Privy Council cases. And related to the Cayman Islands controversy, does the panel think there should be a distinction between the application of the cab rank rule between cases concerning the state's own political community and the application of its laws, versus the application of laws in another jurisdiction to which a barrister may go? And then the next question is, I'm concerned by the fact that we are merely cabs, quote unquote. In other words, that we merely take a case from point A to point B without moral engagement. My concern is not so much that it impacts on the defense of the most vulnerable clients. Often those cases are taken on by lawyers who specialize in those cases and often on a pro bono basis. Is the risk not that the rule supports a lack of moral engagement in those who act for powerful clients against vulnerable clients? E.g., in a recent case for a victim of gender-based violence against her employer, my brief to the employer was pro bono, and the employer was represented by lawyers on remunerated briefs. Throughout through the case, there were a number of times, I thought, when the lawyers on both sides could have been encouraged to act as their best moral selves if they did not have the cab rank fig leaf, but instead had to be accountable for being associated with their client's case. So that point, again, raises similar points to the untenable legal argument, but also to the questions I put earlier about the sort of role of lawyers in relation to their clients and in relation to ensuring their clients act legally and in at least a constitutional setting where values matter consistently with those values. And then another question is, in response to what Helen said, things might be legal or even constitutional, but still opposed to the lawyer's moral conscience. So would it not be possible for lawyers to take ethical responsibility for their decision to represent a party, even if the legal scope for a right is ambiguous? Right, I think that's probably enough. There's more, but I think I should stop there. So I'm just going to take round and you pick out of those what you would like to answer. And maybe we'll go in reverse order, Geoff. Could we start with you and then we'll go Gautam and then Helen?
I think for me, it comes down to the distinction between what is legal and what is morally tolerable. And I think all of those questions come down into those, it all comes down to that sort of question ultimately. I don't think I don't think it's tolerable, let me say this, to take on a case for a client and soft pedal the client's case because you don't like the argument. I think you've got to say to the client, you are entitled to say, and I think you have to say in some circumstances, this is an argument I won't make. And if you want someone who will make that argument, you'd better find somebody else. But I think once you take on the brief, you're obliged to argue it with vigor and such passion as you can muster. And I don't think it's tolerable or permissible should be permissible to soft pedal in any way.
Yeah. Gautam.
Thank you. So I think that it's a really good point. The point about, I think, untenable arguments and you know, and I've seen counsel do that, you know, to decline to make a specific argument. I think the problem arises when it's the law that's untenable, and so if you basically cannot be doing justice to your brief, you know, without making a certain kind of argument. So just again, you know, if you're representing the government minister in a criminal defamation case, you have to demonstrate that criminal defamation has happened. It's so that you can't really dissociate yourself from what the core of the case requires you to establish to win the case. And similarly with the internet shutdown, right? So I think that the problems arise more when you're actually not when you choose not to make untenable arguments in an otherwise tenable case, but when the case is itself what's untenable, you know, morally. So I think that's the issue. I think that also speaks to Nadine, and I'm sorry if I'm mispronouncing the name's point, that you know, that it goes beyond just how you conduct yourself during the case, and we all agree that should be to the highest standards, but it goes a little beyond that, and which is why I think she rightly says that, you know, we're not merely cabs taking a case from point A to point B. And the last point, I think that's what also connects to Rahul's question, which is that should the status of the lawyer impact the application of the cab rank rule? I think that this depends on how I think you view the legal system. So there's one view that the task of lawyers is to assist the court to arrive at the conclusion, and that is what it is. And the other view is that it would be good if that was the case, but in reality, you know, in India, what we call face value, you know, in a very crude way, it matters the face that's before the court. And I think that if the second view is what we subscribe to, that the face matters, then it does, I think, make a difference. The principle remains the same, but I think that it does cast a kind of maybe somewhat higher responsibility on lawyers who know that the court takes them very seriously, you know, what they do and what they don't do.
I mean, that links into another question we didn't get to, Gautam, which is, you know, whether there's a difference here between senior lawyers and junior lawyers, and whether this really isn't a senior lawyer issue largely.
Yeah, so that's a fantastic question, and I don't know what the answer is. I don't think about it. I think it's a really good question, and I was quite struck by it. So yeah.
Okay, great, thank you, Helen.
Yes, so I think it's right to say that we're all ethical beings, and we all have to make our own ethical decisions. But ethics are not uncomplicated. There may be some things where you say, this is my absolute view, I will not do this, and that's that. However, if you become a lawyer, one of the things you're standing for is the system of law and the belief that you will put some faith in a court, and you will say, this is how in our society, how much I may criticise courts or individual judges or the law, but in my society, this is where I think disputes should be ultimately decided, and there is an ethical framework then around what's necessary to make that happen. And it may be that some people say, as they often do, if they say, how can you defend a rapist? And you say, it's not my job to decide if this person is a rapist. I am putting forward the argument within a system where a judge and jury decide that question. Oh, I couldn't possibly do that. Well, okay, that's fine. But you take an ethical view that this is a system worth having and you are prepared to participate in it. I think the edges of that are difficult. There may be cases where people say directly that is a conscience exception, I won't do it. Clearly, I think it is really different in a sort of non-democratic system like the apartheid South African system and a constitutional democracy. But there are those boundaries. But I think the Cabinet rule is designed to put a framework and a sort of shared ethical framework around that. And I think that is a worthwhile thing for it to do. The question is whether it ought to have conscience exceptions in it and the extent to which it should apply to things like governments. And there are questions about that too. But I think as a general shared moral framework, it has a normative value.
Great. Well, that brings us to the end of a really interesting and thoughtful discussion. I'd like to thank all our panelists very much for being here. And also to all of you who've been here, thank you very much for attending. I can see that we've drawn people from all sorts of parts of the world, and that's great. And just to say that in the coming week, there are a range of other events at the Bonavero. Tomorrow, there's a Children's Rights Network group discussion on the sociology of children's rights, which will be presented by Brian Grant from Case Western University. And on Thursday and Friday, for those of you who are practitioners, we've got an online conference on access to justice and class actions in England and Wales. For those of you who are practitioners in the UK, you'll know that there's relatively little use of the class action mechanism, but this draws both on comparative law work from around the Commonwealth on class actions, as well as looking at the kind of theory and practice of class actions. So that's on Thursday the 6th and Friday the 7th, and you'll find details about the program on our website. And then next Tuesday in the Bonavero discussion group, Patricia Viata will be discussing whether companies have human rights and the emerging jurisprudence of the regional human rights courts on the question of whether companies should be understood to be bearers of human rights. And that will be, the discussant there will be Dr. Nick Friedman, formerly at the Bonavero Institute and now in Cambridge. So please join us for any of those events that you think would be interesting, and let people you know around you know about them if you think would be good. Otherwise, just a final thanks to our panelists for joining us for a really interesting conversation, and to all of you, keep well and keep healthy, and hopefully see you again soon. Bye now.
Thank you.